So two of the questions asked this week on the courts kind of revolve around a bigger question: what is the role of the Supreme Court of the United States? And sometimes you will see me refer to the Supreme Court as SCOTUS. So Supreme Court of the United States, SCOTUS. One of the questions was for Wehle Chapter 4, can the Supreme Court Justice deem a law unconstitutional before it is even signed? Can they deem it unconstitutional before a case is presented before them? Really interesting question. I think it's important to kind of explore that. The other question was, who designates which issues should be brought to the Supreme Court? And is there any hierarchy on the issues that are requested to get to the Supreme Court? I think both of these questions are about the process and the role of the Supreme Court in American politics and in American government. So this video presentation is going to kind of explore the broad aspect of the role and the process of the Supreme Court, and then future videos will talk a little bit more about some of the detailed questions that y'all asked. So in terms of thinking about the role of the Supreme Court, it is ultimately the final court of appeal within our judicial system. And the key thing to always remember about cases that come through the judiciary and ultimately could end up in the Supreme Court is that the cases must work their way through that federal court system. This is the principle of what we call ripeness of the case, meaning that the case has worked its way through the entire hierarchy, through the process of the judiciary in order for it to be considered justiciable, or the concept of justiciability in the study of the courts. Now, the U.S. Supreme Court has both original and appellate jurisdiction. And the idea of jurisdiction is simply the power to hear cases, the ability to hear a dispute and resolve it. And this difference between original and appellate jurisdiction plays into how the courts have been structured. Now, for the U.S. Supreme Court, generally most of their cases are dealing with appeals rather than the original trial cases. There are some situations when the U.S. Supreme Court could act as a trial court, meaning they would be the judges, the jury, the presentation of facts before the court. All of that is under the umbrella of original jurisdiction. Generally, the U.S. Supreme Court deals with appellate jurisdiction, or appeals of cases that have already happened. To give you a sense of what an original jurisdiction case might look like for the U.S. Supreme Court, in the past, North Carolina and South Carolina has battled over the issue of water rights, particularly for rivers that flow from North Carolina into South Carolina. Well, the question would be, if the state of South Carolina decided to sue North Carolina, where would the case be heard? Would it be heard in South Carolina, or would it be heard in North Carolina? Well, there's a conflict of interest in terms of having that case heard before either state's courts or within a federal court in either state. So the U.S. Supreme Court would step in and say, we are going to be the original trial case for that kind of dispute. It's very rare, but it has happened in the past. Now, what the court also has that's important to know, along with jurisdiction and the ripeness issue, is the fact that it now possesses what's called a discretionary docket, meaning the court, the U.S. Supreme Court, can decide which cases it will hear. This is very different from the lower level courts that another video will get into. the U.S. Supreme Court can decide which cases they take. And in just a minute, I'll talk about how that process plays out. So the process of granting an appeal. In general, what we tend to see is the issuance of what is called a writ of certiorari, or sometimes you'll hear it just referred to as granting of cert. This is the process by which the U.S. Supreme Court decides we will hear this appeal, we think this case is important enough, and we will issue a writ of certiorari, which is basically a written order to the lower court to send up the records of this particular case. We want to see this case's documents. We want to hear from both sides. So we start this process off by issuing the writ of certiorari or granting cert. And in terms of reaching the Supreme Court through this writ of certiorari or granting of cert, in your book, there on page 238, is the description of reaching the Supreme Court, what the process is all about. And I want to just briefly go through how a case ends up in the U.S. Supreme Court, what all the key steps are. First, at the bottom here, the district court. And you'll see down here, the U.S. district courts, there are 94 districts. They decide the issues of law and fact. How does the facts of the case line up with the respective law? And note that it can be with or without a jury. Once that case is heard, if there is one side not happy with the resolution, it can go to the Circuit Court of Appeals here at this level. And there are 12 circuits there. In another video, I'll be talking about the lower courts and the difference between the lower courts and the Supreme Court. These are the two lower courts that we consider in the federal judiciary system. Now also, cases can reach the Supreme Court through certiorari through the state court systems. And remember, we have one federal court system, but each state has its own state court system. And so we've got one federal, 50 state courts for a total of 51 different judicial systems, 51 different court systems. And the state courts act very similarly to the federal court system in that you have a trial court, which starts down here. Sometimes they're referred to as superior or circuit courts. Again, like with district courts, they are dealing with questions of the law and fact, oftentimes with or without a jury. Then you move up to the intermediate courts of appeals here for the states. 40 states have those. And then you work up to the state Supreme Court. If you are dealing with an issue regarding state law, this is oftentimes the last court of appeal. But if there is what is called a federal question, perhaps that state law may conflict with a federal law or a federal constitutional right, then that case can be appealed up to the U.S. Supreme Court. In terms of the court's process, you get the cert review stage, and I'll talk more about that in just a minute. And this is where petitions from both sides about the legal issues at hand are presented to the justices of the Supreme Court. Now, once the Supreme Court goes through that process, there on page 241 of your textbook, figure 8.6, it gives the Supreme Court's decision-making process. And we get the process of petitions that come before the court. They are lumped into the pool. There's a discuss list and then a conference. And then we have the process of briefs, oral argument, conference, and opinions and dissents. What I want you to do is, as we're working through this video, keep this particular graph in front of you so that you can kind of follow along how I'm laying out the different processes for the Supreme Court to make a decision and issue a particular opinion. So in this process, typically the court will get about 7,000 petitions from across the country for each sitting. And that's what we call a session or term of the U.S. Supreme Court. That term begins always on the first Monday of October, typically runs through June. Now, the court is still working in July, August, and September. They're getting ready for the next sitting. Sometimes justices will take a brief vacation, perhaps go do lectures at law schools. But this is the bulk of the time that the U.S. Supreme Court spends doing their actual work. The cert pool that you see kind of in that second stage, once the petitions are presented, are reviewed by the justices and typically, more importantly, by their clerks. The justices will divide up the petitions that are coming in, and each justice, along with their clerks, will review the petitions to see if there is an important aspect or legal concept that perhaps the U.S. Supreme Court needs to take on and answer. Usually the Solicitor General, and there's going to be a video presentation about the Solicitor General. There was a good question about that particular position. The Solicitor General may weigh in oftentimes on the petitions that are presented and could influence the court to take up a particular case as well. The justices then create a discussion list for when they meet in conference, and all 9 justices will gather around. I'll talk about the conference aspect in just a minute, but they'll gather around and discuss the various petitions that each justice thinks is an important case for the court to take up. Now, in order for the court to hear a case out of this discussion list and this cert pool, we have what is called the Rule of 4. It takes 4 justices to say, we need to hear this particular case. This is an important case for us as the nation's highest court to resolve. Now remember, there are 9 justices on the court at this time, and if the case is granted, then the subject matter is deemed important to at least 4 justices. But what's a majority of 9? That's a majority of 5. And so there could be some political strategy going on when it comes to determining what kind of cases to take and ultimately what kind of outcome there could be. If the Rule of 4 is invoked, then you basically are granting certiorari, you are granting cert, and typically out of those 7,000 petitions, about 75 cases are heard each term. So you can see the great number of petitions that come before the Supreme Court, but based on their discretionary docket, they typically only take about 75 cases to hear. If a case is accepted, you then get briefs from both sides of the issue that has been litigated in the lower courts, but you also get what are called amicus briefs from interested parties. And typically very controversial cases will attract a lot of attention and will attract a lot of amicus briefs, otherwise known as friend of the court briefs. They are wanting to present a particular legal aspect, perhaps a particular constitutional aspect to this case. The court opens it up and lets people weigh in on that process. Once the briefs have been submitted and the case is ready, we then have what are called oral arguments. And typically this is twice a week, oral arguments on one case in the morning and then another case in the afternoon. And that's typically scheduled twice a week, sometimes 3 times a week. During oral arguments, each side gets 30 minutes to present their particular case, and oftentimes you will hear the justices break in with questions. Oftentimes, each side's counselor or attorney that's presenting it will only get a little bit of the way into their argument that they had planned out when the justices start peppering them with questions. And oftentimes you will hear about, well, what about this particular aspect? Or what about this aspect of the law and how it's applied in this case? So it is very much a dynamic kind of relationship between the 9 justices, who oftentimes interrupt each other, asking questions, and the counselor that has to present their particular side. Once the oral arguments are held, the justices then discuss the case in conference. And what they do is they go into their conference room. There are 9 justices, so you will see 9 chairs seated around this conference table, and there is nobody else in the room. Only the 9 justices debate the particular question and the case at hand. Each justice is allowed to present their views, what they think are the issues of the particular case, and once they do that, there's then a vote on the case's outcome. How many individuals think about this particular case and the particular outcome, and a vote is then taken. Now, if the Chief Justice of the United States is in the majority, the Chief Justice can write the majority opinion or assign it to a justice who is also in the majority. But what happens if the Chief Justice is in the minority, is on the losing side of this particular issue? If the Chief Justice is in the minority, then the senior ranking Associate Justice in the majority either has the opportunity to write the opinion for herself or himself, or can assign the opinion to someone in the majority. And this is the process of opinion writing, another critical stage of the Supreme Court's process. Once we get into the opinion writing process, this is where some of the more pronounced politics of the court comes into play. Typically, you will see different types of opinions being issued. As was mentioned earlier, you have the majority opinion. This is going to be the opinion that rules on this particular case and may set what is called precedent, the future of how a particular law or the Constitution is viewed. You could also have what is called a concurring opinion or a concurrence. This is in agreement with the majority's outcome, but a justice writes to say, I would look at it this way, or I would deal with this particular law or the constitutionality in a different approach from the majority's approach. Finally, you could have a dissenting opinion, and this is oftentimes written by justices who do not agree with the majority's opinion, would have rendered a different decision, or perhaps used the law in a different way from what the majority constructed. The opinions oftentimes get shopped around, and this can be where some of the bargaining, some of the politics of the court comes into play. Typically, majority opinions will be shopped around and perhaps looked for new votes or new arguments. Remember, if it's a 5-4 decision, the flip of one justice could be critical in terms of how that particular law, how that particular case, what the constitutionality of that particular issue may be rendered. So this is a critical kind of political aspect to the opinion writing process. Majority opinions tend to be distributed around to the justices to kind of even out the workload so that all justices have an opportunity to write majority opinions. They can write their own dissents or their own concurrences, but if they're assigned a majority opinion, that's kind of distribution of the work and the load for the Supreme Court. Finally, the written opinions for each case are announced, what are called announcements. They are released to the public. Sometimes dissents, justices who dissent from a majority opinion, they have the opportunity to read their dissent from the bench. And this is oftentimes a real signal of the serious nature of the disagreement among the court members. It doesn't mean that the court members don't like each other, but sometimes you will hear dissents being read from the bench, and this is a signal that this was a controversial case and differences of opinion were among the justices. Most of the big controversial cases of the term tend to be in May and June, but they can be scattered around throughout the session's term as the court is sitting. And once a decision is released, you will see Congress, you will see the public, you will see the president, you will see the public react to them in many different ways. And so most of all the controversial issues in American politics tend to end up in court being dealt with ultimately by the Supreme Court. So just as kind of a wrap up in terms of kind of the general questions regarding can a Supreme Court justice deem a law unconstitutional even before it's signed into law? No, because of the issue of rightness, because of the issue of justiciability, you have to be able to have the law be challenged in court, go through the process, and then end up in the Supreme Court. And then the other question, who designates which issues to be brought up to the Supreme Court? It's the Supreme Court itself. Through the granting of certiorari, through the rule of 4, the court and its discretionary docket gets to handle whichever issues they want to deal with in terms of being presented out of those 7,000 petitions.